Smith. I'm the Secretary of State for the Housing and Communities, Local Government and others.
Thank you.
Good morning, my Lord.
Yes, Mr. Willis.
I appear on behalf of the appellant in this appeal.
Yeah.
My learned, together with, I should add, my learned junior, Mr. Tessa Buchanan, sits behind me.
Yes.
We're also accompanied by a pupil today from my chambers. So we're not, as it were,
good.
Heavy-handed, but we've got the benefit of my pupils' thoughts as well. My learned friend, Mr. Mould QC, appears on behalf of the first respondent. The second respondent does not appear. The interested party, Mr. Amos Wilshire, who is the owner of the land, does not appear, but through my instructing solicitors has been contacted and has been asked whether or not he would wish to make representations. He said that he would not, but that he supports the submissions that I make on behalf of the appellant.
Right, I see.
I think that came through by way of I think the message may have come through by way of an email to your Lordship's clerk, or at least the listing.
Well, I'm not sure that that's reached me, but you've said it now to make the position very clear. No doubt the email is in the system and will find its way to us eventually.
Yes.
But you've made it very clear now. This hearing, as you know, is being live streamed, so those watching from afar will have heard me say that. So don't have any worries on that score. We understand.
I'm grateful. We'll also find for your Lordship the address to which that email was sent.
Yes, if you would, that would be very kind. What happens sometimes, as you know, is that things find their way into parts of the system and take a little while to get to other parts of the system. That may have happened here, I think.
It may well have done, my Lord. My Lord, as far as others in the court are concerned, and I can't identify everybody, but the interveners are at least two of the witnesses who have. Forgive me. One of the witnesses for the interveners, Miss Siobhan Spencer, MBE, sits behind me with glasses on her forehead, on her head, and Miss Debbie Kennett appears to her left as we look. She's the director of the London Gypsy and Travellers, and Mr. Chris Johnson, the solicitor, is here for the interveners generally.
So all those who should be here, as it were, are here.
They are.
Physically here or present remotely, but observing through the live stream arrangement.
Exactly, my Lord. Thank you.
Yes.
My Lord, can I just address documents?
Of course, yes.
And ask your Lordships to confirm that you have the core bundle, the supplementary bundle, the authorities bundle.
Yes.
And then that obviously includes both our skeleton arguments.
That's right.
Which I think should be in the replacement format with the
they are.
Appropriate pagination.
They are. Thank you very much for that. And you can assume, for your part, that the court is reasonably familiar with the materials before it. So you can assume that in opening the case. And if we do need you to carry on anything in particular, we'll make that clear as we go.
Thank you very much, my Lord.
Just on timetable broadly, a day and a half has been set down for this hearing. I think for my part, though I've not discussed it with my colleagues, that this hearing should comfortably finish in that time allocation for it. Is that the view of council?
It is.
Yes, it is.
Have you, between you, discussed timetable?
Very briefly, I mentioned to Mr. Moore that I thought that I would finish and aim to finish by 3 p.m.
Yep.
Today. That gives enough time for this.
Depending, obviously, on how we go in terms of the issues, I may well that may enable me to complete my submissions today.
I see.
But if not, I'll be a long way through them. By the time your Lordship rises.
All right, well that's helpful. Thank you very much. Yes.
Thank you, my Lord. So, can I begin by perhaps just outlining, in summary, the grounds of appeal?
Yes.
Which are aimed at the decision of Mr. Justice Pepperall sitting in the planning court
Yeah.
on the Section 288 application made by the appellant, whereby she challenged the inspector's decision to refuse her planning permission in both permanent planning permission and temporary planning permission form. The grounds of appeal, my lords, you'll find at page CB 50 of the bundle, but if I can perhaps just summarise them.
Yeah.
Ground one is in summary, an argument that the judge wrongly applied the test in paragraph 88 of the Christian Institute case,
Yes.
and having done so, wrongly held that the appellant had a high hurdle to surmount, and he was also wrong to decide that it was the appellant that had the burden of showing that the policy was not capable of being operated in a lawful manner. And indeed, he was wrong to conclude that the policy was justified because it was capable of being so operated.
Yeah.
So in essence, what we say is that the learned judge wrongly reversed the burden of proof and imposed a higher standard of proof on the appellant to boot. What we say is that the Christian Institute test has no application in cases of indirect discrimination brought by a victim of the discrimination. That this isn't an ab ante case. And one can go further and say that in the context of the claim under Section 19 of the Equality Act 2010, putting aside the Convention Article 14 claim, it had absolutely no applicability. That's ground one in essence, in summary. On ground two, we say that the learned judge wrongly held that the appellant could not rely upon race discrimination. We contend that the appellant, through counsel, pleaded race discrimination. But when one looks carefully at those, at the pleaded case, the Part 8 claim form, and I'm not going to take you to it, it's not express. I accept it, it's not express, it's implicit, but not expressly pleaded. In fact, the protective characteristics aren't expressly pleaded, even in the context of disability and age. But the point about race discrimination in this case is, if I might say so, it's something of an elephant in the room. It's a case where the impact on elderly and disabled members of the Gypsy and Traveller population is intrinsically bound up with their ability to live their traditional way of life in caravans. It just cannot be ignored, whether it be pleaded or not, and certainly can't be ignored in my respectful submission by this court, and ought not to have been ignored by Mr. Justice Pepperall, when considering the purported justification for the difference in treatment, the purported safety valve, if I can put it that way, or mitigation, which was that ethnic gypsies and travellers who could no longer travel because of old age or ill health could nevertheless rely on their Article 8 rights, the material consideration which would have to be taken into account, their personal circumstances, and the national planning policy framework. Yeah. With respect, that purported safety valve is flawed, given that it involves what I'm going to call flimenos indirect discrimination. Taking the definition of indirect discrimination as identified in the Flimenos against Greece case by the European Court of Human Rights, which amounts to or involves treating people with differences the same. Yeah. So whether one uses the race discrimination, if I can put it that way, as a sword or a shield. The reality is that the impact of the change in the definition on the protected characteristic of race is obvious. It can't be ignored. And certainly when this court comes to consider the Article 14 claim, given that this court has a duty under Section 6 of the Human Rights Act 1998 to act compatibly with the Convention. So it would be rather strange if in as it were, undertaking the exercise and complying with that duty, nevertheless the court itself could be satisfied that a measure was justified by virtue of a situation that resulted in flimenos indirect discrimination. So that's ground two. As far as the legitimate aim ground is concerned, ground three, we say in essence that the learned judge erred in terms of his identification of the legitimate aim. Yeah. He focused on the aim of the planning policy for Travellers Site policy document as opposed to the change in the definition. It was the measure, the change to the definition, which he needed to consider. And it was the aim of that definition change that he needed to identify before then considering its impact, and then whether or not the aim was rationally connected to the objective, and if it was, whether nevertheless a fair balance was struck. So the whole, as it were, analysis of the learned judge in the court below, putting aside the Christian Institute point, was flawed because of the, as it were, the failure to identify the legitimate aim of the measure as opposed to the policy as a whole. And then on ground four, we say that whether or not your lordships are with us on the other grounds, justification has to be based on very weighty circumstances or very weighty reasons in a case where the discrimination is admittedly going to have an impact on characteristics which are known as suspect or treated as suspect, which include, putting aside race, disability. And in circumstances where the discrimination impacted on disabled gypsies and travellers, the learned judge ought to have given the purported justification very close scrutiny. Clearly, we say he didn't because he applied the wrong test under the Christian Institute case. But had he taken the correct approach, he would have then analysed the complaints that the appellant made about the whole process, and particularly looked at the evidence before him of the factors that were taken into account at the time that the decision was being taken, or before the decision was taken to amend the definition. And that evidence one can find in the witness statement of Simon Gallagher and the contemporaneous material that he exhibits. And it's quite clear that far from there being, as it were, objective evidence to justify the policy change, the Secretary of State acted on perception, a perception of unfairness.
I think it's an understanding of perception of unfairness.
My Lord, yes, sorry. Apologies.
I think that's how it's put.
Yes, and understanding.
Which might be regarded as, you would say, thin.
Flimsy, my Lord, yes. And certainly not the sort of reasons that one could reasonably conclude should amount or could amount to objective and reasonable justification.
Is this right, that grounds 3 and 4 in a way run together because they're both concerned with justification?
My Lord, yes.
I mean, legitimate. we're asked to look at legitimate aim as part of justification.
My lord, yes. Yeah.
I mean, you've separated them out very helpfully, but that they all go to that point.
They do, my lord. In essence, we say that the judge went wrong when looking at justification, and an element of that was his conclusion as to the legitimate aim, which I hope, being fair to my learned friend, was very much the way that the case was put by Mr. Mould on his feet. Before the sorry, on his feet. We were in a virtual hearing, but in the court below. Yes. And your lordships would have seen that having put the case, as my learned friend did, in terms of the legitimate aim, during his submissions before Mr. Justice Pepperall, the claimant, as she then was, through us, put in additional submissions in response. I think I'm right in saying that, but perhaps. Sorry, forgive me. I think that point was actually one which I meant to make in relation to the Christian Institute case, having been raised by my learned friend. So ignore that, please.
But anyway, the argument you've outlined is what you put before us.
It is, my lord. And what we say is that the evidence that was before the learned judge, and it was consisted of Mr. Gallagher's witness statement, no other. Yeah. So, as it were, the conclusion that the legitimate aim was something other than the evidence given and adduced by the Secretary of State in the form of Mr. Gallagher's witness statement and the exhibits, could only have come from the learned judge's acceptance of my learned friend's submissions that the legitimate aim was somewhat different. What we say that the learned judge also failed to do was to look at the position in practice. And we've referred you to the case of Nur, which is a first instance decision of Mr. David Locke QC. But it's an approach which we say is apposite in a case of indirect discrimination, because indirect discrimination is all about the impact of a policy or practice or condition. And one can only judge whether or not there is objective and reasonable justification for its imposition in circumstances where it indirectly discriminates against people with a particular protected characteristic. If one looks at the impact in practice, and one sees that reflected not just in Mr. David Locke QC's judgment, but also in the judgment of Lord Justice Lewison in the Ward case, which I'm going to take you to briefly.
Yes.
And then finally, we respectfully submit that the learned judge erred by finding that the measure, that's the planning policy definition change, was justified by reference to what we're going to describe as a factor of universal application, which is perhaps harking back to what I said earlier on about the ability to rely upon one's Article 8 rights, personal circumstances, and the national planning policy framework, which is, albeit in each and every case, whether one's a gypsy or traveller or a gorger, as we're known, non-gypsy travellers, will be different.
Yeah.
Well, that's in summary our case.
That's very helpful, thank you.
Thank you. What we say, and this is perhaps a jury point, but if I can make it anyway, is that it's a cruel irony that those who have perhaps experienced all their lives difficulties obtaining planning permission, finding a place to stop in order to live in accordance with their traditional way of life, as a result of the historical under-provision of sites for gypsies and travellers, should then be excluded from the relaxed policy regime, if one can call it that, in planning policy for travellers' sites, exactly when they need it the most. when they can no longer travel because of their ill health or old age. I've talked about gypsies and travellers, and just perhaps worthwhile touching on who I'm talking about for the benefit of anybody in the court and on the bench who has not had experience of working of cases involving gypsies and travellers.
Well, I think we all have, but I wouldn't wish to stop you doing this at all.
Very, very briefly, my lord. Gypsies and travellers as a term can mean different things, and different things to different people. But it will encompass Romany gypsies, an ethnic group who descend from, forgive me, tribes who left India about 1,000 years ago and travelled through Europe, some stopping in Europe and others continuing to these shores, where legislation passed by Henry VIII shows that they were certainly present by 1535, because it was then that the Egyptians Act was passed, which banned Romany gypsies, or Egyptians as they were known then, from these shores. And we have, from then on, legislation which addresses gypsies and travellers, some of which is relevant to these proceedings. But gypsies and travellers also includes other groups, and Romany gypsies are themselves recognised as an ethnic minority, entitled to protection under the Equality Act, but so too are Irish travellers. And Irish travellers are, indeed the material that we have before us includes a reference to them, having been identified as such, as a separate group, back before even the Middle Ages. But they came to these shores perhaps more frequently in the 19th century. And there are many now that have lived in this country all their lives. A separate ethnic group, again, recognised as such through case law, which has tested the point. The term also includes Scottish gypsy travellers, but we're not dealing with cases involving Scotland, and Welsh gypsy travellers, also known as Cale. And then, in addition, the term encompasses those who perhaps were once known as New Age travellers, but are now more regularly known as new travellers, although perhaps even that term is no longer apposite, given many of them have travelled all their lives, and the word new perhaps isn't quite appropriate for them, but not members of an ethnic group.
No.
So that's the term generally, but in this case I'm representing a Romany gypsy, and our case is put on Article 14 of the European Convention on Human Rights, but also Section 19 of the Equality Act. And the point is that a new traveller would not be able to rely on Section 19 of the Equality Act, because certainly they would not be entitled to protection, given that they don't have a protected characteristic recognised by the Act. That's not to say they wouldn't be able to argue under Article 14 and other status that their rights might have been infringed, but that's not this case. I've talked about ethnicity and indeed other groups, or at least one other group that comes perhaps within the general use of the term gypsies and travellers, but then we have the planning definition. Yeah. In fact, a statutory definition first set out in the Caravan Sites Act in 1968. And Mr. Justice Pepperall helpfully provides us with a useful and accurate summary of the planning definition. And you'll see, my lord, that core bundle, page 4, the judgment begins. Yeah. And paragraph 6, under the heading planning definition of gypsies, yes. The learned judge accurately, I may say so, sets out the legislative and policy history, as it were, of the definition, going through the 1960 Act, as he begins on paragraph 6, with a quote from Mr. Justice Sedley, as he then was in the Atkinson case. By the way, that quote is in fact to be found in tab 20 in the judgment of Chapman. Perhaps if I just give you your note.
Want to look at Chapman, or?
Well, perhaps we can just take a moment to look at it, my lord, if you don't mind. Tab 20, page 644 of the authorities bundle.
Yeah, thank you.
And the reference to Mr. Justice Sedley in paragraph 6 of Mr. Justice Pepperall's judgment is to this quote at paragraph 45, where the learned judge, Mr. Justice Sedley, was referring to the Criminal Justice and Public Order Act, which introduced additional enforcement powers to deal with Gypsy and Traveller unauthorised encampments, at the same time as repealing a duty imposed on local authorities to provide sites. And he says that, well, perhaps I can let your lordship read it.
Mm. Thank you.
The authority.
Yes.
Thank you, my lord. So Mr. Justice Pepperall sets out the history of the development of the definition, and that runs through to planning policy for travellers' sites, which was first published in March of 2012. You'll see that picked up at paragraph 20 of Mr. Justice Pepperall's judgment, and then revised in 2015. And in that revision, one sees the policy definition change, which we're now concerned with. If one looks at paragraph 21 of Justice Pepperall's judgment, and your lordship will see there, and we've got the document itself in the bundle, but he sets out the policy. The policy's overarching aim. So at the very bottom of page 8 of the core bundle, the government's overarching aim is to ensure fair and equal treatment for travellers in a way that facilitates the traditional and nomadic way of life of travellers while respecting the interests of the settled community. And it's just worth noting, my lords, that particularly given that my learned friend's argument relies in part upon the judgment of this court in the Wrexham case,
Yes.
which concerned an earlier circular 1 of 1994, issued at about the same time as the duty to provide sites was repealed. That circular, which we have in the authority bundle at tab 26, set out its main intentions, page 750 of the authorities bundle.
Would you like us to look at it?
Well, just briefly, my lord.
Yeah.
It's the first bullet or dash point at page 750. And the wording is slightly different from that which one sees in planning policy for travellers' sites. The first paragraph, paragraph 1, last sentence. The circular comes into effect immediately. Its main intentions are, first bullet point, to provide that the planning system recognises the need for accommodation consistent with Gypsies' nomadic lifestyle. It may be a subtle difference, but there is a difference in the circular 194 intentions. And
could you show them the definition? Paragraph 5.
Definition.
What
Oh, yes,
by
yeah,
gypsies?
Yeah. My learned friends asked me to just turn over the page to paragraph 5.
Yeah.
And one can see there the word gypsies. So the word that has just been identified in the first bullet point, paragraph 1. Gypsies are defined in Section 16 of the 1968 Act, that's the Caravan Sites Act, as persons in a nomadic habit of life, whatever their race or origin. References to gypsies in this circular are references to gypsies in that sense. The term does not include members of an organised group of travelling show people or circus people travelling together as such. Planning advice relating to travelling show people is given in another circular. So the definition that was relevant for the purposes of Circular 194 was actually the statutory definition at the time set out in the Caravan Sites Act 1968.
That's what Mr. Justice Pepperall says at paragraph 9 of his
Yeah,
judgment.
exactly, madam. Yes.
The circular adopted the definition in section 16. Yeah. And then it's under that act, is this right? That act and that definition that we get a Wrexham case.
Yes.
Long before the Equality Act.
2003, I think it was.
Well, the Wrexham case postdated the Equality Act 2010.
No, predated.
Sorry.
Your lordship's correct.
Yeah.
I'm sorry, predated, yes.
Wrexham was before the Equality Act.
Apologies.
But and what they were considering was Circular 194 and the definition in the 68 Act.
Yes, my lord, in the statute.
Yeah.
And a definition which your lordship will have noted is different from the definition which one finds in the Planning Policy for Travellers Site, Annex 1. Because as the learned judge in the court below identified in paragraph 24, it begins with the words, persons in a nomadic habit of life, whatever their race or origin, and ends with the words, but excluding members of an organised group of travelling show people or circus people travelling together as such. But there are additional words, and they are these, including such persons who on grounds only of their own or their families or dependents' educational or health needs or old age have ceased to travel temporarily. Those words you will not find in the statutory definition in section 16 of the Caravan Sites Act, which, to complicate matters, was then, on repeal, inserted into the earlier statute, the Caravan Sites and Control and Development Act, as the learned judge identified in his judgment.
The legislative framework under consideration in Wrexham is set out in the preliminary parts of the judgment. It's at tab 19 in the authorities bundle.
My lord, yes.
Which reflects, I think, what you've
I hope so.
said to us. I'm not asking us to go there, it's simply to record that was the frame within which that decision of this court was made.
My lord, yes. And my Lord Justice Coulson's quite right on the chronology. Forgive me, I was befuddled for a moment in terms of the fact that the Wrexham case is somewhat dated now, 2003, and predated the Equality Act of 2010. What one won't find in the Wrexham case was any submission made by by the respondent in that case, who were defending the decision of Mr. Justice Sullivan, as he then was, whereby Mr. Justice Sullivan upheld the inspector's decision to, I suppose, recognise or bestow gypsy status, as it was then called, upon Mr. Berry and his family in circumstances where they had retired effectively on grounds of ill health from travelling. And what one will not find in that judgment is any reference to either Article 14 of the European Convention on Human Rights or the then relevant legislation addressing disability or race. The Sex Discrimination Act and the Race Relations Act. Those weren't matters that were raised by any party or indeed the court, and that judgment is not and cannot be binding on this court's determination of whether or not the definition in Planning Policy for Travel Sites, version 2015, is justified in terms of the indirect discrimination that it imposes on people like the appellant.
Mr. Willis, before we go on, in the light of the history which you've just outlined,
Yes.
Is there any significance one way or the other in the fact that both the 2012 and 2015 policies define the overarching aim by reference to, quote, the traditional and nomadic way of life? Is that two features as opposed to nomadic life, which is one feature?
My Lord, in my respectful submission, it is significant that we are no longer dealing with a policy which has the overarching or main intention of, as it were, facilitating the gypsy nomadic way of life, but rather traditional and nomadic way of life.
It's
What
possible,
I would respectfully...
just to help on
Yes.
this, because I think this is an important question that we need to focus on. And it would be very helpful to have your considered submissions on this. What is the force of that linking and traditional and nomadic? Is it to create, as my Lord puts it to you, two concepts effectively, one of which may subsume or partly subsume the other?
Yes.
Or is it, or does the and really have no function beyond that which a comma would have? This may be actually quite an important point. I'm sorry, I don't want to cut across my Lord's question, but I'm interested in your answer to it for that reason.
Certainly, my Lord. I understand. There are, I would respectfully suggest, two, probably more, but two important pillars or facets of the traditional ethnic gypsy and traveller way of life. One is born out of the other. But nomadism is one, and for many reasons, a nomadic way of life is becoming increasingly difficult for ethnic gypsies and travellers, not least because of the coming into effect of the Police Crime Sentencing and Courts Act 2020 provisions only yesterday. But the other essential element, recognised as it was in the Chapman case as an integral part of the traditional way of life, is living in caravans. Now, as I said, that may well have resulted from that traditional way of life of living in caravans. Indeed, I'm sure it has, from the nomadic way of life that many gypsies and travellers used to pursue and would still do so if they could, whether it be because there were transit sites and stopping places that they could use, or alternatively if they were fit enough to do so. But those two pillars, those two facets, are key, I would respectfully submit, to the traditional way of life of ethnic gypsies and travellers. And so the use of the words the traditional and nomadic way of life, as opposed to the traditional nomadic, for example, is significant, and it, in my respectful submission, widens out the policy in PPTS 2015, and indeed for that matter 2012, because the overarching aim was exactly the same in both policies. Beyond the main intention in Circular 1 of 1994, which was much more limited and related expressly to nomadism. Now, as your lordship were asking me the question, I was looking at Circular 1 of 2006, which was the intervening policy adopted by the Secretary of State in 2006. And
wasn't that the key one, though?
Sorry.
Wasn't that the key one, the one in 2006? Because that's the one that first included
Exactly.
those that had stopped travelling permanently.
It was the first introduction of following the Wrexham case, with the judgment that we've seen and read, the government decided to extend the definition to include not just those that had ceased travelling, perhaps for long periods of time, but effectively temporarily, for example, to look after elderly or disabled members of their family, or to ensure that their children were educated, but then with the intention of resuming travelling thereafter. But extended it beyond that to those who had ceased travelling permanently on grounds of old age or ill health. And I'm reading that, my lord, from Circular 1 of 2006, which is at tab 25 of the authorities bundle, page 727, paragraph 15. That's where one finds the definition.
Sorry, page 7.
727, my lord.
Yeah.
And I'm looking then at page 726 at the main intentions of the circular. That's first at paragraph 3 at 725. A new circular is necessary because evidence shows that the advice set out in Circular 194 has failed to deliver adequate sites for gypsies and travellers in many areas of England over the last 10 years. Since the issue of Circular 194 and the repeal of local authorities' duty to provide gypsy and traveller sites, there have been more applications for private gypsy and traveller sites. This has not resulted in the necessary increase in provision. And then paragraph 12, main intentions. And A indicates that it's intended to create and support sustainable, respectful and inclusive communities where gypsies and travellers have fair access to suitable accommodation, education, health and welfare provision, where there's mutual respect and consideration between all communities for the rights and responsibilities of each community and individual, and where there's respect between individuals and communities towards the environments in which they live and work. And a number of other intentions, my lord. But I'm not sure that, well, perhaps just turning over the page back to 727, one can see a reference to some gypsies and travellers having an actively itinerant lifestyle, including groups of long-distance travellers and are generally self-employed people, sometimes occupied in scrap and scrap metal dealing, laying tar macadam, seasonal and agricultural work, casual labouring and other employment. These traditional patterns of work are, however, changing and the community has generally become more settled. And then, for example, a reduction of seasonal agriculture and related work has led to more travellers working in trades which require less mobility.
Wait, sorry, where exactly are you reading?
Paragraph 17.
Oh yes, 17.
727.
Yeah. What one notices there is the use of the word traditional in the context of patterns of work.
Yes, my lord.
And one notices the same word traditional in a different context at 12D, the previous page. The traditional travelling way of life.
Yes.
Etc. So we have, though, what I haven't done is the exercise of seeing if there are other uses of the word traditional. But there are two facets of traditional way of life, if you like, in those two paragraphs at least. Is that right?
Yes, my lord, that's right. The nomadic way of life, although and the traditional patterns of work, which are changing, and the circular recognising, as was said in 17, that the community has generally become more settled. 19 indicates is where the government indicates that a more settled existence can prove beneficial to some gypsies and travellers in terms of access to health, education services and employment, and can contribute to greater integration and social inclusion within local communities. What we don't...
But I'm sorry to interrupt,
Sorry, no,
Mr. Willers, but my eye falls on the words a little bit further on.
Yes.
Nevertheless, the ability to travel remains an important part of gypsy and traveller culture.
Absolutely. And so what one sees this policy in Circular 1 of 2006 addressing thereafter is the provision of sites which can be used, because the definition is wide in paragraph 15, for those who continue to travel for work, not just as part of their culture, but in order to earn a living. Those that have ceased travelling for work in order to educate their children, perhaps, or look after resident dependents, members of an extended family, for example, and also sites which will accommodate those who have ceased travelling permanently on grounds of old age or ill health. All those people can benefit from the definition, and either on their own or in an extended family group, perhaps, be entitled to gypsy status, and then rely on the more permissive policies within Circular 1 of 2006. What one sees is that that definition is then transposed into planning policy for travellers' sites, published in 2012, and we've included a copy of that document in the sorry, forgive me.
In the core bundle, I think.
In the core bundle, yes. I think it's.
Oh, sorry, you took out 2012 or?
2012. Yes.
Well, 2012, I think, is in the authorities. Oh, sorry, in the supplementary bundle, isn't it? I'm sorry, I'm not being helpful. It's 24 in the authorities bundle.
24, yes. Tab 24. Very grateful for your lordships and my learned friends sitting behind me. And we can see that it begins at page 710, tab 24, and the introduction is at 714. And the overarching aim is set out in paragraph 3, and it's in exactly the same form of words as one sees in PPTS 2015, the version that we're now concerned with. Overarching aim.
Which is a potentially important point.
My Lord,
because
yes, because
you've got a policy that includes permanent, that is said to balance the interests of the traditional way of life and the interests of the settled community. And then you've got a definition without it, but the same aim.
The same aim, my Lord. The aim hasn't changed. The definition has.
And can I just ask this?
Yes.
Purely, the settled community, does that mean me?
My Lord, it does. But not just you, my Lord.
Well, I understand that. I'm using myself unusually, perhaps, as a generic example of somebody who lives in a house.
Which you might describe as a solipsistic question.
So it doesn't mean, when it talks about the settled community, it's not talking about gypsies and travellers who have settled temporarily or permanently. It's talking about everybody all those who live in a house or a
yeah, it
flat
would include
permanent.
all those who live in conventional housing. It could be said to include ethnic gypsies and travellers who are living in bricks and mortar accommodation, but it's not. It's not
fine. Okay, because there's talking in the policy document you were showing us in 2006,
yeah.
when it talks about people who are settled in the context of gypsies and travellers. That's why I just thought I'd make sure.
Yes.
That's what I assumed.
You're right, my Lord.
Yeah.
To assume that.
Okay, sorry, we were looking at the 2012 policy.
Oh, and yes, and my learned friend says, and it would include also those who they're not just living in bricks and mortar accommodation, but perhaps those living in park homes. And there are many park homes up and down the country,
Yes.
as we know. So,
Yes.
but I think it's aimed at the interests of the settled community. It can be taken as those who are primarily not ethnic gypsies and travellers, but certainly not those who live on gypsy sites.
You make the point very clearly just now that the aim has not changed,
Yes.
but the policy has, and that may be an important submission. You would acknowledge, would you, that I'm not sure if this is argued on the other side or not, but I mean, just logically speaking, I suppose, the aim can be the same and the policy can nevertheless change and still serve it.
Yes.
I suppose if the policy were to be regarded as having gone further than it needed to satisfy or serve the aim. So you'd need to probably to address that concept as well. Well, you do, I think, in your argument.
We do, my lord. But one of the things I'd say is that the words, the traditional and nomadic way of life, ought, in our respectful submission, to address both those pillars or important facets of the way of life of ethnic gypsies and travellers. And it's noteworthy that the aim hasn't changed. It could have changed. It hasn't. What we say in essence is that when one looks at the evidence produced by Mr. Gallagher, who frankly, to be fair to Mr. Gallagher, wasn't present when this process was undertaken. He's a historian in effect, providing us with the material, the documentary material that was created contemporaneously.
Well, that's not unusual, is it?
No,
in
no,
these
not
sorts
at
of
all.
cases. I mean, Mr. Gallagher is saying, here's the kit, here's the relevant kit that we rely on for justification.
My lord, yes. But without being too flippant or about it, and I will go through it, but it's our submission that there was an edict from on high that the definition should be changed so that effectively the only people who could benefit from it were those that were still travelling. Travellers should mean travelling, or that one continues to travel. And so ultimately the definition was changed, but the definition change doesn't reflect the overarching aim. What's been left out of account by the decision makers in this case is the right to respect for one's traditional way of life, an integral part of which involves living in caravans.
Yes, nobody is arguing or could that the traditional way of life, whatever that encompasses, has materially changed.
No.
In the various steps of, or sequential steps of policy making.
No, I suppose the only point I would make about that is that there has been some change, and it was recognised in Circular 1 of 2006, in that ethnic gypsies and travellers are finding it more difficult to travel because of the various enforcement powers and the advent of wide injunctions and other ways of addressing unauthorised encampments, and the lack of provision of transit sites and stopping places, such that the tendency is for gypsies and travellers to spend more time settled on a site.
Yes, but your submission would be, I take it, that the traditional way of life, whatever it is something settled and secure over centuries.
Yes.
Through force of circumstances, including planning circumstances, it has been constrained, you
Yes.
submit, I think, to us, but the essential traditions are are enduring. Is that a
Exactly.
fair way to?
Yes, that's a very fair way of
Encapsulated,
putting it. It
yes.
includes not just living in caravans, but things such as cleanliness within caravans, separation of,
Yeah.
you know, cooking facilities
Yeah.
and washing facilities and various other traditional practices, which no doubt are born out of perhaps the descent from northern India, but also necessity in terms of when one lives in a small confined space, in order to avoid, you know, the what might otherwise occur in such a small space.
I'm sorry, Mr. Willis, I missed that. You said yes, I was living in caravans, but you then went on to say about other traditional facets, but you just gave some examples. But I
did, but I was thinking about examples which come under the classification of practices which avoid pollution, for want of a better word. But for example, ethnic Romani Gypsies tend to, not all ascribe to this, but tend, when living in caravans, to ensure that their cooking facilities are kept away from their washing facilities. By ensuring that the two are kept separate, they then minimise the risk of infection and the like, and a lot of that is borne out, as I said, possibly of practices that stem from their descent from India, but also possibly out of necessity when travelling and living in caravans in such small spaces.
Literally traditional in the sense that they are handed down or on from one generation to the next.
Yes.
Yeah.
I suppose the evidence that the interveners have provided about culture and practices and the strength of commitment to living in caravans is something that I wasn't going to take your lordships to, but for your note, can I invite your lordships to perhaps, before considering your judgment, review the evidence given by Dr. Siobhan Spencer, MBE, who has identified who sits in court today. Her evidence is at pages of the supplementary bundle 23 to 25.
Yes.
The evidence of Abby Kirkby of Friends, Families and Travellers at supplementary bundle page 44. And there she recounts under the heading at page 47, the heading Cultural Significance of Living in a Caravan, some accounts given by Romani Gypsies and Irish travellers of their way of life. And although I'm not going to take you through it in any detail, I'd invite you to read through those references. And the strength of commitment to caravan living, the traditional element of that part of the culture of Romani Gypsies and Irish travellers has also been recognised, just as an aside, by this court indeed, in the case of Clark against the Secretary of State for Environment, Transport and Regions, as it then was, and that was the case where a Romani Gypsy and his wife were offered bricks and mortar accommodation. And when it came to them seeking planning permission for a Gypsy site, the inspector on appeal took account of the fact that they'd been offered bricks and mortar accommodation and refused them permission, and on a challenge under Section 288 of the Town and Country Planning Act, and indeed subsequently on a further appeal to this court, the court accepted that that offer should not have been taken into account in circumstances where the Romani Gypsy had a strong cultural aversion to bricks and mortar. So these points are not simply points which members of the communities make, but have been recognised as being valid by this court. Those accounts given by Abby Kirkby in her witness statement include one given by Charmaine Valor, page 48.
Yes. Paragraph 5.
Sorry, paragraph 5, yes. So Charmaine Valor, Romany Gypsy, former trustee and former employee of Friends, Families and Travellers, states, Romany is something that you're born. It's not something you can create or mimic. It's a way of life from the second you take your first breath. That first breath. Romanys have such a strong belief in tradition and family, and we have our own traditions which are passed down through generation after generation, which goes back hundreds of years, which the wider community cannot understand even in the 21st century. When asked why it's so important to live in a trailer, well, I find this a very strange question. To me, it's part of my life, and that's all I've ever known. And she then talks about being affected by living in bricks and mortar, mental health suffering as a consequence, feeling isolated. And it's worth noting that Charmaine Vallow gets a mention later on in this witness statement.
Interestingly, sorry, I don't want
forgive me.
to hold you back, but you in the passage you didn't read.
Yes,
the rest
sorry.
at the top. No, not at all. Top of the next page, which does go very much to my Lord's question. I think every one of them said that they felt isolated from their families, and that a lot of their traditions that they could not take part in because they lived in a house.
My Lord, yes.
That's perhaps an echo of the distinction you were drawing in answer to my Lord's question.
My Lord, yes. I mean, I don't want to make too much of it.
No.
But,
I simply draw attention to it because
Yes.
it did seem very much to go to my Lord's question.
yes, if I could ask your Lordships to just perhaps take the time to review those accounts, just to give your Lordships an understanding of the strength of feeling, the depth of the commitment to living in caravans at ethnic gypsies and travellers hold. But having touched on Charmaine Valor, I think rather than come back to it later, can I just draw your attention to paragraph 33 at page 58, because the appellant is not the only Romany gypsy who has had difficulty obtaining planning permission in circumstances where she's been denied the benefit of reliance on planning policy for travellers sites as a result of the definition change. Charmaine Valor, the former trustee of Friends, Families and Travellers, recounts at paragraph 33 to 38 the rather extraordinary situation where permission was granted on a temporary basis for a gypsy site for her husband, Mr. Smith, paragraph 35, whom she cares for, but not for her to live on the same site, because she was deemed not to be entitled to gypsy status because she had effectively ceased travelling on grounds of ill health, which is identified, that ill health being identified in paragraph 37. The reality is that she still travels to the site to care for her husband, who also suffers from health conditions. But it's just an example of the nonsensical and inhumane, perhaps to use the word deployed by Mr. Justice Sullivan, as he was in the first instance decision in Wrexham, of this policy definition change. There are other impacts, and my lords, one of them is clearly the sort of problems that have arisen for the appellant and her family. One only has to look at the decision letter to see that the inspector, having concluded that the appellant and her family could not qualify for gypsy status, addressed the merits of her planning appeal on the basis of the national planning policy framework, and rather than on the more permissive provisions in PPTF, 2015, and refused her planning permission for temporary planning permission because it was considered that it would be of no benefit to the appellant because she wouldn't be able to qualify for it because of a condition that was imposed which required compliance with the definition. But that's not the end of the impacts that the policy definition will have on the appellant and her family, because if push comes to shove and she's forced to leave the site, then she will not be able to obtain or to move on to an authorised gypsy or traveller site run by the local authority, because those sites are also subject to the definition. She would not be able to move on to any private rented site where compliance with the definition was a requirement for the residents either. And on top of that, one can see from the evidence presented by the interveners that the definition itself is now being used, as the planning policy for traveller sites policy requires, for the assessment of the needs of gypsies and travellers. And its application has resulted in a significant, at least 50%, reduction in the assessed need for caravan pitches for gypsy and traveller households. Now that point wouldn't be so bad if there was a concomitant or a concurrent process going on whereby what are sometimes called non-PPTS gypsies and travellers' needs were being properly assessed and addressed. But we don't have that situation at this point in time. We have a report from the Equality and Human Rights Commission, which we've included in the bundle at the very back of the supplementary bundle, page 281, sorry, forgive me, of the supplementary bundle. It's the best evidence before this court because this exercise hasn't been carried out by those instructing my learned friend. It wasn't carried out at the time that the definition change was contemplated, and it hasn't been carried out since. And it's headed Gypsy and Traveller Sites, the revised planning definition's impact on assessing accommodation needs. And
it's September 2019.
it is, my lord. So, and indeed, I recollect my learned friend indicating to Mr. Justice Pepperall that there was going to be some guidance produced to give to local authorities as to how they should assess the needs of non-PPTS gypsies and travellers. That was back in December of 2020, and we haven't had that guidance yet. And in the meantime, as certainly up until 2019, one can see that this review of 20 local planning authorities' approach to identifying and meeting the needs of gypsies and travellers found that there was a problem. And at page 287, one can see 5 key findings. A heading at the bottom of the page. And this conclusion, across the 20 local planning authorities, the pre-2015 total requirement was for 1,584 further pitches. So assessments that had been carried out before the application of the 2015 PPTS definition resulted in a requirement for 1,584 further pitches. After the revised definition was introduced, the assessed need fell to just 345. Another way of looking at this is that instead of 100% of accommodation need coming within the PPTS definition, we found that since August of 2015, this figure is nearer 15% of assessed households. The local planning authorities identified up to 450 additional pitches for households whose travelling status had not been ascertained, And my understanding is that those whose travelling status has not been ascertained resulted from the fact that they could not be contacted and interviewed to ascertain what their intentions were and whether they complied with the definition. Turning over the page and skipping over the first paragraph, the review indicated that while 8 local planning authorities had plans that aimed to meet the accommodation needs of non-PPTS gypsies and travellers, i.e. those who do not meet the current definition, the remainder of the LPAs do not. So it's a postcode lottery as to whether ethnic non-PPTS gypsies and travellers will have provision made for them. And then there's a reference to planning inspectors examining local plans, having made reference to equality and human rights considerations, but the outcome in both cases ultimately failed to ensure that the LPAs in question made any substantive provision within those plans for non-PPTS gypsies and travellers. And finally, the approach of the various GTAA's Gypsy and Traveller accommodation assessments highlights some methodological issues in assessing gypsy and traveller need that the revised 2015 definition is presented.
You gave us, I thought I heard you say 50% as the significant reduction in assessed need.
Yes, I said up to 50%. If one looks at the 5 key findings,
Yeah.
It's rather more than that.
Yes.
Indeed, Mr. Justice Pepperall accepted the evidence given by Dr. Siobhan Spencer that it was up to 75%.
Yeah. No, I just was wondering where the 50% figure came
What-
from. This suggests it's rather more than that.
It does, my lord. I'm erring on the side of caution, being as it were conservative in my approach. But if one adds from that first key finding, the assessed need fell to just 345, with the fact that the local planning authorities identified up to 450 additional pitches, one gets to nearly half the figure of 1,584.
Oh, I see. So this is net need, not gross need.
Well, my lord, it's slightly different from that. What's been assessed is a need for those who comply with the definition of just 345. 450 other families couldn't be needs couldn't be assessed. So those are the families that have been identified as needing additional pitches, despite the fact their travelling status has not been ascertained. The question then is whether or not all those pitches would be provided. And the report goes on to say, perhaps I can just...
In fact, sorry, just to pause you there, the first key finding, if you aggregate 3, 4, 5 and 450, you get almost exactly to 50%, 1584. Almost exactly.
That's where I got the figure of 50% from, my lord. But it's fair to say that not all of those 450 pitches for those whose travelling status is unknown will necessarily be provided, because if one looks at page 296, 297, under the heading Summary of Findings, and this is maybe my own friend Mr. Mould has similar experience, but
you get the same numbers there, don't we?
We get the same numbers, but then looking over the page at 297, one can see the third paragraph. The local planning authorities took various approaches to the unknown households whose status could not be determined. For example, Aylesbury Vale and Central Bedfordshire included 100% of their unknowns. In other words, they would make provision for all of those that they hadn't ascertained the traveller status within their need figures, while others only included 10%. So that figure of 450 was a figure attributed to those whose status was not known. But the question of whether or not pitches would be allocated or land identified where they could be was within the gift of the local authority.
So there's a degree of estimation going on here according to different judgments, authority by authority. And the submission may be, the safe submission may be that there has been, on any view, a significant reduction in need or net need for pitches as a consequence of the policy.
My lord, yes. And what the exact figure may be is debatable, but it's 50% or higher. And indeed,
I think the 75%, or almost 75%, I think that comes from Dr. Spencer's evidence, and I think that's what the judge referred to in his judgment.
he did, my lord, and the figure is included.
You've got the 73% on 296. I don't know if that's the corresponding.
Oh, well, maybe
That,
it is.
yes,
Because Dr. Spencer refers to the report of the EHRC
yes.
and says led to a sharp drop of almost 75%. So that would appear
Yes.
appear to tally, yeah.
It's it does tally, my lord. It's the last paragraph of page 296, as my lord Justice Lindblom indicated. But I've effectively accepted that it one can safely work on 50%, and there's a figure between 50 and 75%, or 73%, which is significant by any measure. So and these are all matters that the learned judge in the court below accepted. Indeed, he outlined the evidence provided by the interveners and the appellant of stark inequalities faced by gypsies and travellers, the lack of site provision, the difficulties in securing planning permission, all under the heading the gypsy experience, and concluded that, having accepted as well the evidence given by Dr. Spencer and others, that there was an endemic problem and a disproportionality experienced by gypsies and travellers, a disproportionate difficulty, I think were the words he used, faced by many gypsies and travellers in obtaining planning permission. And it's not, this is a difficulty that hasn't just arisen, but it's made a lot worse, we would respectfully submit, in the case of elderly and disabled gypsies and travellers, given that they can't now rely on the PPTS permissive policies. Now, that's reflected, those difficulties are reflected in evidence given by Dr. Simon Ruston, a planning consultant, with a doctorate on the definition of gypsy and travellers, would you believe?
Page 12.
My lord, yes. Page 12 of the supplementary bundle. And none of this evidence was gainsaid, as it were, by the Secretary of State, but he identifies the impact of the new definition on decision making, and this again make a number of jury points. I'm sorry, but paragraph 23 is perhaps where he ends up on this point. I'm not going to address you on the compliance with the family test. It's not a point we've pushed. But the point here, he says,
paragraph 23 is going back to your point that the proof of the pudding is that notwithstanding all of these points, as it were, in the appellant's favour,
yes,
it doesn't work. So and that's a reflection of your other point, that if the scales are tilted,
yes,
then adding to both sides doesn't change the tilt of the scales.
my lord, yes, Lord Justice Lewison's point in the Ward case.
Yeah.
And what we're not talking about here a site in the green belt or an area of outstanding natural beauty or any other sort of designation. I'm not suggesting for one moment that one should disregard the impact on the countryside and the surrounding character of it. But severe health considerations and caring responsibilities, a family in desperate need and not even able to obtain temporary planning permission. But and not the only example in the evidence that I've already taken your lordships to. I'm going to move on from Dr. Ruston's evidence. And forgive me, I've just forgotten my train of thought. Just to mention this other point, my lord, which doesn't affect at this point in time the appellant, indeed, perhaps never will if the definition remains as it is. But those gypsies and travellers, ethnic gypsies and travellers, who are currently living on a site with planning permission, with, as is ordinarily the case, a condition that they comply with the definition of what it means to be a gypsy or traveller, will be, and have been indeed since 2015, at jeopardy of being the subject of enforcement action for non-compliance with that condition, which could lead to their ultimate eviction by use of powers under the Town and Country Planning Act, whether that be by means of an enforcement notice and prosecution, or an injunction under Section 187B of the Town and Country Planning Act, or ultimately direct action. And
well, speaking for myself, Mr. Willis, this was, when I looked at the papers, this was one of the points that sort of slightly jumps out at you. One morning you could be on a site lawfully, and the following morning you're there unlawfully. And doubtless Mr. Mole will take us to the justification for that. But on the face of it, that's taking away an accrued right.
my lord, yes.
Which in public law generally is not usually done.
And all the more so when one is talking about one's home, and a lawful home at that, and taking away the home, the established lawful home of someone who is a member of our society, European society, but our society accepts is a vulnerable community, with there being no option, one might think, given the other elements of the other impacts of the definition change, than for that family to either move onto the roadside, but possibly suffer the deprivations of doing so, and be subject to the enforcement provisions which I've touched on already, or move into conventional housing and give up their traditional way of life. And your lordship's right, it does, it stands out as being fundamentally unfair. And in my respectful submission, there can be no justification for the impact on those living, whether it be on their own site or on a council site or a private site, where the enforcement officer comes along and says to the landlord, are all of your residents complying with the definition? I mean, one only has to think of the reason why they might do that. Nothing to do with racism or prejudice or wanting to clear the site, but perhaps rather to ensure that there's a pitch available for a family that's on the roadside already. So there may be very good reasons, particularly relating to a family with dire needs, but nevertheless, the family that already has the lawful accommodation and may have lived on it for many years. Indeed, that would be the reason why they would then be subject to enforcement, perhaps because they have settled on it.
That's not the ostensible aim of the policy.
It's not. It doesn't get a mention in the public sector equality analyses.
No, that if you like, balancing of the needs of one family against
I see.
Another. I mean, that's not inherent, is it, in the objective?
No. If one, perhaps we should go to the.
It was only because you said, you see, that in your scenario, which was prompted by my lord's question, the enforcement officer coming along to the site might be perfectly well intentioned.
Yes.
On the basis that you described, but actually, is that any part of the aim of the policy?
No.
To to balance needs, to say, well, this family is down the road on the roadside.
No.
This family has an elderly grandfather with health problems. There's a balancing.
I will take you to the contemporaneous material. It doesn't, in those terms, deal with the example I'm giving, which I think is a practical example that could occur. What it does suggest was going through the minds of the civil servants and ultimately the decision maker was that with a number of elderly and disabled gypsies and travellers taken out of the definition, there would be less competition for the pitches that were available. But it doesn't contemplate the possibility of, as it were, one family being evicted so that another on the roadside could be transplanted. Indeed, what would happen is that the family that was evicted would then ultimately almost certainly be on the roadside unless they were able to move into housing. So it would be nonsensical. But sorry,
I'm sorry to interrupt you, Mr. Wills, but I suppose a further complicating feature in this, listening to your submissions, is that within any given family, there's no reason to suppose that they'll all become unable to travel at the same time.
Yes.
And so when my lord spoke of the appearance of taking away an accrued right,
yes.
There'll be very difficult family decisions to be made because those who would still qualify will have to decide whether to give up their accrued right in order to remain together as a family.
My lord, yes. I mean, we've looked at the example of Charmaine Valmer. Her position is perhaps not as acute as might otherwise be the case because she's at least able to travel to care for her husband who is living on the site, and so it appears that unsatisfactory as it is, they're still able to maintain that relationship. But there'll be other situations.
Quite apart from the human aspect.
Yes.
I'm just thinking about the assessed need aspect.
Well, yes.
You've got a family of 4. Actually, 3 of them still do have a legitimate need. There's only one who's, to borrow a sporting phrase, had to hang up his boots.
Yes.
But the end result may be that all 4 have to move out, or maybe only one moves out.
My lord, yes.
In terms of assessing the need, it's rather a shifting target, perhaps.
It only serves, I would respectfully submit, to complicate the assessment of need. But there is, again, recognition that the definition change may have the effect of splitting up families. And that is touched upon in the contemporaneous material. Nevertheless, it's considered proportionate that the definition change be imposed because it was considered that it would ensure fairness within the planning system, which, as I said to my Lord Justice Coulson, was based on in my respectful submission, the flimsiest of foundations. My Lord, I've been jumping around a little, but and not going anywhere near what was going to be my order of.
Well, do you want us to pause and take stock? Just
if I could
pause,
for a moment.
Pause for a moment, and then perhaps you could indicate what the plan is from where we are.
Can I take some very brief?
Of course, yes.
It's been given in. Sorry, Mark.
Yes, my Lord rightly makes the observation that at some point, maybe quite soon, we need to turn to the substance of the grounds because you indicated that you would probably take until about 3, which is effectively 2 more hours.
Exactly the point made by my learning.
So you've got to
when are you going to get to the ground?
It's coming at you from both sides.
And my learning friend will probably say.
Mr. Mulder saying nothing.
when my intervention is supported by your junior. Those are the very rare occasions when I feel right.
Anything that my learned junior says is right with me. So thank you, my lord. So ground one, please.
All right.
We've identified our case on ground one in our skeleton argument at paragraphs 11 to 34. And just before I turn to that, the paragraphs above, this is at page 71 of the core bundle, if you've got the skeleton argument in it. We set out some preliminary points, which I think I've now addressed, paragraph 6 to 10. And then ground one, we begin with our, as it were, assault on the learned judge's decision to apply the Christian Institute test, the higher hurdle test, to this case. And one could see that we've set out a quote from Baroness Hale, paragraph 2 of the BB judgment, the English language competence test case, if you remember,
Yeah.
Which emanated from the immigration rules, which were then challenged, and followed up by the reference to the Supreme Court decision in the Christian Institute case. And the quote there, which the learned judge then included in paragraph 71 of his judgment. This court has explained that an ab ante challenge to the validity of legislation on the basis of a lack of proportionality faces a high hurdle. If a legislative provision is capable of being operated in a manner which is compatible with the Convention rights, in that it will not give rise to an unjustified interference with Article 8 rights in all or almost all cases, the legislation itself will not be compatible with Convention rights. And we accept that, as indeed Lord Justice Hickinbottom indicated in the JCWI case, which is then referred to in paragraph 13 and 14, that the same points were intended to be made in relation to Article 14, albeit that the cases that were then being considered were not indirect discrimination cases, but direct.
Mr. Willis, we didn't do ab ante at my red brick university, or if we did, I was away. 20 years after Lord Wolfe, here we are. What does it mean? Round my way, we don't often say this is an ab ante challenge. What does it mean?
Likewise, my lord, although I do remember how to decline the verb up to love. But ab ante was a new one on me when I saw it the first time looking at the Christian Institute case. But my interpretation of it in this context means a challenge which is made by an individual who is not a victim of the discrimination or the measure that is challenged, whether it be on grounds of under Article 8 or Article 14 of the Convention, that it's a challenge which, I mean, from before, I think, is possibly the way that one would literally interpret it, if one were to translate the Latin to English.
It's a challenge to the validity of legislation, really, at the time that legislation is passed, before anybody can say definitely whether somebody is a victim or not.
Yes.
So it's a sort of abstract challenge before the event.
Yes.
Anticipatory.
Yes.
I think we're all agreed on that, my lord. What we're not agreed on, my learned friend and I, in any event, is that is not what this case is. We say, paragraph 16, that the learned judge was wrong to apply the ab ante test, or the Christian Institute JCWI test, Paragraph 17, the appellant's case was not an ab ante challenge. The appellant has been personally affected and disadvantaged by the provision in question. We've been there already and seen, certainly in the form of the decision letter, the impact, but I've taken you through other subsequent impacts that the definition change may have on her and her family in the future. In paragraph 18, we note that the judge held that the Christian Institute threshold applied to the appellant because her claim is not that the inspector had discriminated against her, forgive me, in the exercise of her planning judgment, but that PTS 2015 itself is inherently discriminatory. We say that, with respect, his reasoning is misconceived on this point, because this case is a typical archetypal indirect discrimination claim. It's about a provision or criterion or practice. You'll see those words in the quote from section 19 of the Equality Act in paragraph 19 below, which is discriminatory in that it has an impact on a relevant protected characteristic of the appellant. And the same can be said for Article 14 of the European Convention on Human Rights, where indirect discrimination may arise where a neutrally formulated measure affects a disproportionate number of members of a group or person sharing the characteristic, which is alleged to be the ground of discrimination. In the case of SC against the Secretary of State for Work and Pensions is the thought of that quote. Perhaps I can take you to that judgment, my Lord. It's at tab 7, begins at page 67 of the bundle of authorities. And this is the tax credits case, the two-child limit case, decided by the Supreme Court in 2021, I believe.
Yes.
And the quote itself comes, that I've just recounted, comes from paragraph 53, page 98 of the bundle. Can I just ask your lordships to read paragraph 53 and then make a comment on it? Because, sorry,
Yeah.
because it's not just the quote that I've outlined that is important. There, Lord Reid really sets out, in essence, a summary of the approach that must be taken in a case where indirect discrimination is admitted. Once a prima facie case, 5 lines down, my lord, of indirect discrimination has been established, the burden shifts to the state to show that the indirect difference in treatment is not discriminatory. The state can discharge that burden by establishing that the difference in the impact of the measure in question is a result of objective factors unrelated to any discrimination on the ground alleged. This requires the state to demonstrate that the measure in question has an objective and reasonable justification. In other words, that it pursues a legitimate aim by proportionate means. And what we say is that in this case, having wrongly applied the Christian Institute test, the learned judge in the court below went wrong. He having wrongly applied that test, wrongly concluded that it was for the appellant to show that the policy was incapable of being operated in a convention compliant or otherwise lawful manner. And he was wrong to find that the appellant had a high hurdle to surmount, and ultimately wrong to conclude that the measure was justified having regard to that test and that reverse burden of proof. Wrong to conclude that the measure was justified because the planning system as a whole was capable, theoretically capable, of taking into account the needs and or Article 8 rights of formerly nomadic, non-PPTS Gypsies and Travellers.
So can I just be sure that I understand that submission? You say that the judge was wrong to apply the Christian Institute test, I understand that. But it goes further because you say that that then effectively tainted how he dealt with justification, because you say he was wrong to approach it on the basis of whether it was theoretically capable of dealing with the planning needs of, in this case, the appellant. Have I got that right?
You have, my lord. I mean, it resulted in the learned judge, I think these words have been used in the skeleton argument, looking at the issue from the wrong end of the telescope, or taking a wrong turn, and looking not at the practical implications and effects of the definition change, but rather at the theoretical capability of a gypsy or traveller being able to obtain planning permission by reliance not on PPTS, given that they wouldn't comply with the definition, but rather on their Article 8 rights, their personal circumstances. And by looking at the capability, the theoretical capability, all the material that the learned judge rightly accepted showed that there was an endemic problem, that the system had gone wrong, was put to one side. I mean, one could be forgiven for thinking that reading the judgment up to about paragraph 48, he's going to find in favour of the appellant. But then all that evidence that the learned judge accepted was put to one side because he adopted the wrong test. And a test which is wholly inappropriate in circumstances where there's an acceptance, certainly an allegation of indirect discrimination, which requires justification.
Well, as to that, you just say once there's accepted to be indirect discrimination, it just becomes about justification.
My lord, yes. And that requires very weighty reasons from the decision maker.
Yeah, well, that's the point you've made.
Now, if we agreed with that argument, what do you say about what we should do? We should ourselves, as it were, step in and scrutinise the justification and reach a view on that,
Yes.
or remit it for that to be done below.
We've indicated in our skeleton argument that we would invite your lordships to review the justification. Whether or not your lordships decide to do that is
a matter for us.
Matter for your lordships. Yes. But we say that given the evidence that is included in the core and supplementary bundle, and particularly the evidence of Mr. Gallagher, your lordships would be quite able to undertake that assessment. There's no need for any further evidence. There's been plenty of opportunity for the respondent to submit evidence in the court below, and indeed, well, not that it would necessarily be admitted at this late stage, but it seems that your lordships are in as good a position as a judge in the court below should the matter be remitted to determine that matter. So there's in paragraph 21 a summary of the cases of BB and Christian Institute and JCWI, and just moving over paragraph 22 to 23, we say that indirect discrimination cases are a fundamentally different category. An indirect discrimination challenge depends on group disadvantage. It will apply to all those with the relevant protected characteristics who've been put to the relevant disadvantage, and that the definition puts disabled and elderly gypsies and travellers at a particular disadvantage, an accepted disadvantage. Then it's got to be justified, and if it can't be justified, it will be unlawful in all cases. If it can, it will be lawful in all cases. So the question whether or not the measure is capable of being operated in a manner which is compatible with convention rights is simply inapposite. It's not how discrimination on an indirect basis works. I'm not asking you to ignore paragraph 25, but moving on in order to speed things up slightly. Paragraph 26, we make the point that even if we're wrong that the BB Christian Institute JCWI test doesn't apply to indirect discrimination, it cannot apply with respect to the appellant's case as far as it's based on the Equality Act, because section 19 of the Equality Act contains a complete statutory code as to when indirect discrimination will take place. There's no room for implying a further burdensome test on the claimant. And then we summarise our case in paragraph 27. Make the point in 28 that the learned judge, consequently having adopted that test, imposed a higher standard of proof and reversed the burden of proof to boot. And in reality, going back to the case of SC, which I took you to, paragraph 53, the appellant had nothing to prove. The burden lay entirely on the first respondent as the policymaker to justify the discriminatory definition. And that is also reflected in the judgment of Lord Justice Lewison in the Ward case, a case concerning an Irish traveller and the allocation of housing accommodation. My Lord, we address the ground one in even more detail, as it were, moving through the paragraphs that follow, and summarise it in paragraph 34.
I took paragraph 30 onwards as being effectively your potential report. If it was suggested, well, yes, the judge did refer to Christian Institute, but even if it was accepted that that was wrong, well, it didn't have any effect.
Yes.
That was the purpose of my earlier question to you. Your submission is, yes, it did look at 30 onwards.
My Lord, that's right. But I mean, in fact, my learned friend's skeleton argument came in after this, obviously, as one would expect, and that's not the argument put forward by Mr. Lord. So, unless it's raised on his feet.
So 30 to 34, well, 30 to
33
yes.
would be rebuttal.
Really a rebuttal to an argument that hasn't crystallised.
Yes. Thank you.
Thank you.
Can I then turn to ground two, my Lord? And I mean, I have summarised it already, but and it's a fairly simple argument, which is based upon what we know about the impacts of the policy definition on ethnic gypsies and travellers, that it will impact on their ability to live in caravans in accordance with their traditional way of life, that being a key facet of that traditional way of life. And if I can just take the Lordships back to the Chapman decision, and this is where we touched on it earlier when I took you to the quote from Mr. Justice Sedley's judgment in Atkinson. but your lordship probably will be familiar with the Chapman judgment.
Yeah.
But in essence, and it's now 21 years of age, but it was a challenge brought by a Romany gypsy in respect of the UK planning system and its enforcement powers and their use in her case. And it was argued by Mrs. Chapman that enforcement action taken against her, she was fined for breach of an enforcement notice which required her to cease using land for residential purposes as a caravan site for her and her family. But that enforcement action infringed her, in fact violated her rights protected by Articles 8 and 14 of the Convention. And the judgment was a majority, the decision was a majority decision. 10 judges concluded that there had been no violation of her rights protected by the Convention. There were some strong but dissenting opinions by 7 of the judges, which you'll find at the end of the judgment, should you wish to look at it. But the point was that the court itself, all 17 judges accepted, when one looks at paragraph 73, page 652 of the authorities bundle.
One of the judges in the majority was
Sir Nicholas.
Sir Conrad Sheeman.
Oh, yeah, sorry, forgive me, he was the ad hoc judge, yes.
Yes.
And so...
familiar with the planning system.
Very familiar, my lord, yes. And in fact, one can see, I think, perhaps his work in the judgment when it comes to the preamble to the findings made by the court, because if one turns through the facts from page 635, there is a detailed recounting of the inspector's decision letter in an appeal case, and then 640 relevant domestic law and procedure and practice. And none of it can be faulted in terms of its accuracy. Page 642, the Caravan Sites Act gets a mention, and the definition, as it then was set out in the legislation at paragraph 29. The Criminal Justice and Public Order Act, which is where I took you with, is at 643, where I took you for Mr. Justice Sedley's quote, Circular 1 of 1994, and in addition, let's just touch on this, paragraph 66, page 650, under the heading The Organisation for Security and Cooperation in Europe, a report produced by that organisation provided a quote which is set out at the bottom of page 650, and just over the page, 651, end of the first line, a 1986 report, appreciate it's somewhat dated, by the Department of Environment described the prospects of applying for planning permission for a gypsy site as a daunting one, laced with many opportunities for failure. In 1991, the last years in which the success of application rates was evaluated, it was ascertained that 90% of applications for planning permission by gypsies were denied. In contrast, 80% of all planning applications were granted during the same period. About 5 lines down, my lord. As such, virtually all gypsy planning applications are highly contentious, and I should just ask you to read the previous paragraph, the previous sentence.
Whilst I'm sure you would say the generic difficulties are the same, this is obviously evidence of some antiquity.
It is, my lord, yes. There's a reference to those figures in Mr. Justice Pepperall's judgment, I recollect.
Right.
But it is of antiquity.
Compared to, for example, the report you were showing us from September 2019 from the
Policy and Human Rights.
Human Rights.
Yeah. What?
So we were coming to the judgment where...
Yeah, yes. Perhaps just before we do, my lord, I think that can I take the opportunity to make the point that the lack of any proper review of the success rates or otherwise of Gypsies and Travellers since the early 1990s is a point in the appellant's favour, I would respectfully submit, when it comes to the question of justification and indeed the degree of deference that your lordships might show to the decision maker. Because measures which are indirectly discriminatory have to be objectively justified, and we just don't and we won't see that objective justification when we look at Mr. Gallagher's evidence. So I was going to take you to the judgment, and page 652, under the heading "As to the rights in issue under Article 8 of the Convention," you'll see at paragraph 73, this being said by the court considers that the applicant's occupation of her caravan is an integral part of her ethnic identity as a gypsy, reflecting the long tradition of that minority of following a travelling lifestyle. This is the case even though under the pressure of development and diverse policies, or from their own volition, many gypsies no longer live a wholly nomadic existence, and increasingly settle for long periods in one place in order to facilitate, for example, the education of their children. Measures which affect the applicant's stationing of her caravans have therefore a wider impact than on the right to respect for the home. They also affect her ability to maintain her identity as a gypsy and to lead her private and family life in accordance with that tradition. And that is a finding which has been accepted by this court, as I said in the case of Clark against the Secretary of State for the Environment, Transport and Regions, but also in other decisions, including the decision of South Buckinghamshire District Council against Porter, which ended up in the House of Lords on 2 occasions. And
you say it was accepted in Clark.
Yes.
At some point, but not now. There's a reference in Mr. Justice Pepperall's judgment to the first instance decision, because that's Mr. Justice Burton's rat-infested barn point.
Yes.
But I don't think I've got a reference to it in the Court of Appeal. Not now, but at some point.
I will identify that for your lordship, and if I can find a copy, I will find a copy.
I don't worry about a copy, just the reference. Would be.
The other paragraph which is key to our argument, my lord, is paragraph 96 at page 658. And there the court, in the majority judgment, makes this point. Although the fact of being a member of a minority with a traditional lifestyle different from that of the majority of the society does not confer an immunity from general laws intended to safeguard assets common to the whole society, such as the environment, it may have an incidence in the manner in which such laws are to be implemented. As intimated in another judgment, the Buckley against United Kingdom judgment, the vulnerable position of gypsies as a minority means that some special consideration should be given to their needs and their different lifestyle, both in the relevant regulatory planning framework and in arriving at decisions in particular cases. To this extent, there is thus a positive obligation imposed on the contracting state by virtue of Article 8 to facilitate the gypsy way of life. Well, that positive obligation is also a factor, an important factor in my respectful submission for your lordships to weigh in the balance. Should you, when it comes to, which I hope it will come to, a point where I hope it will come to, where you assess whether or not the justification advanced by my learned friend and the respondent for the definition change passes muster. So we've talked already about I've made submissions already about the 2 primary, perhaps key facets of the traditional way of life of ethnic gypsies and travellers, living in caravans and nomadism, although one is more constrained, they're both constrained, but one certainly more constrained than the other. And what we say in relation to ground 2 is that one cannot divorce the assessment of the impact of the definition change on age and disability from the fact that it also has an impact on the ability of Romany gypsies and Irish travellers to live in accordance with their traditional way of life. Whether or not it's pleaded, and I accept that it's not expressly pleaded in the particulars of in the Part 8 claim form, they're certainly referred to. Elderly
This
and
is a
disabled
slightly odd
gypsies.
thing about this ground. The whole case is about gypsies and travellers. The word race isn't used, but the whole framework of the claim is about gypsies and travellers, and the policy is about gypsies and travellers.
Yes, and it was understood in the, I keep saying we'll go there, but the material of exhibited by Mr. Gallagher, that the impact would be on ethnic gypsies and travellers who were disabled or elderly.
And the judge has a section of the judgment, the gypsy experience.
Yes, and accepted the evidence that had been put before him and the reports that identified that the difficulties that they face in living in accordance with their traditional way of life and the other inequalities that stem from that, such as poor outcomes in terms of health and education and the like. And so our key point really is here that race is, or ethnicity is, inextricably linked to the protected characteristics which one cannot argue were pleaded. And so it's impossible for any proper assessment of the justification to ignore ethnicity. And the learned judge was, with respect, wrong then to do so, or to debar the appellant from being entitled to rely on that additional protected characteristic. It's not.
What difference does it make as a matter of practicality for us?
Yes. Well, it makes this difference that the addition of the protected characteristic of race calls for, dare I say, even greater scrutiny, even more stringent scrutiny than would otherwise be called for when the court was looking at a suspect ground such as disability. And perhaps it adds really nothing, because we say our case is strong and the respondent's case on justification is weak. But when it comes to authority,
you can point to Chapman for the positive obligation point. You can point to I can't remember which case it is now, but one of the cases on disability that talks about very weighty reasons.
Exactly.
So you've got a positive obligation one way, very weighty reasons for the justification the other. I understand the debate you had with my Lord Justice Holroyde in relation to the traditional and the submissions you've made about that. So it could be said it might make a difference there, but does it make a difference beyond that?
Well,
I mean, I'm not asking that question, prompting you to say no, that's fine. It doesn't make a difference. I genuinely am trying to identify what difference it might make.
my lord, yes, I understand. And there are, when it comes to the degree of deference and the weight of the reasons that need to be advanced and accepted to justify discrimination of this nature, everything depends on the circumstances, and disability has a protected characteristic impacted by a measure, requires very weighty reasons, and I'm taking your lordship, if I might, back to the decision of the Supreme Court in the SC case against the Secretary of State for Work and Pensions, tab 7, begins at page 67. But you'll see that sidelined from page 110 under the heading manifestly without reasonable foundation and JD and A against the United Kingdom, Lord Reid, in quite a lengthy passage, provides chapter and verse really on the meaning of that term, its application, and the very weighty reasons requirement. And he goes through the case law where very weighty reasons are said to be required. And if I can take you to paragraph 112, at page 114, you'll see that he says there a relatively strict approach has also been adopted in cases concerned with persons with disabilities in order to foster their full participation and integration in society. And then he refers to a case of Glore and a more recent case of Guberina. And he says that case concerned a refusal of to grant a tax exemption for persons with special accommodation needs to the father of a disabled child. And the court noted that on the one hand, a wide margin is usually allowed to the state under the condition when it comes to general measures of economic or social strategy, including measures on the area of taxation. On the other hand, it continued, and this is, I would respectfully submit, applicable in this instance too, that if a restriction on fundamental rights applies to a particularly vulnerable group in society that has suffered considerable discrimination in the past, then the state's margin of appreciation is substantially narrower, and it must have very weighty reasons for the restrictions in question. The reason for this approach, which questions certain classifications per se, is that such groups were historically subject to prejudice with lasting consequences resulting in their social exclusion. Such prejudice could entail legislated stereotyping which prohibits the individualised evaluation of their capacities and needs. Well, my lord, that paragraph could well have been written, in my respectful submission, about the very circumstances that are before us. We have indirect discrimination, which results in a restriction on the fundamental rights of particularly vulnerable members of a particularly vulnerable group. One might think the most vulnerable members of a particularly vulnerable group, the elderly and the disabled. Just thinking about the elderly, they may be the people who are most likely to have lived in caravans for the longest, possibly born in a caravan and would wish to die in a caravan.
And the test there is very weighty reasons, which is what the judge said, although your submission is he didn't apply that. Yes. That's a separate point. But that's the test identified.
It is, my lord. There is another aspect to the learned judge's failure to, as it were, grapple with the race protective characteristic, and that is the fact that he, in doing so, rejected the argument put forward, and I refer to it as perhaps being more of a shield than a sword, but an argument that the Secretary of State's rationale or perhaps justification for requiring or changing the definition was that non-PPTS Gypsies and Travellers would be entitled to rely on the exactly the same regime as the settled community. In other words, seeking planning permission under the National Planning Policy Framework and relying, insofar as they can, on their Article 8 rights and personal circumstances and the like. And that, we say, is an example of Claimant discrimination, which is equally unlawful. But having concluded that race was not a protected characteristic that the appellant could rely upon in this case, he concluded that that wasn't a point that he could take into account. So that's perhaps the long and the short of it. The strict scrutiny that, I think I used the word stringent scrutiny, that one must have regard to or apply to justification when one is looking at race, is a point that I take from a decision of the Court of Appeal, this court, in the case of Elias. And
Tab 18.
I'm very grateful.
Page 548.
Yes, 548, thank you. And paragraph 161, which your lordships will find at 585 of the authorities bundle. And this is a decision of Lord Justice Mummery, or at least the judgment of Lord Justice Mummery. And there, 4 lines down, he says, a stringent standard of scrutiny of the claim justification is appropriate because the discrimination, though indirect in form, is so closely related in substance to the direct form of discrimination on grounds of national origins, which can never be justified. If this is the correct approach, as I think it is, it's difficult for the Secretary of State to rely on a wide margin of appreciation or a broader discretionary judgment. And he goes on to refer to a speech of Lord Fraser of Tully Belton in another case, which he says supports the stringent standards of scrutiny in seeking to justify indirect discrimination, which is closely related to racial grounds.
Say stringent standard of scrutiny.
My lord, yes. My recollection is that Lord Reid, having, as we've seen, he really he set out the law on very weighty reasons in some detail. Has also covered off this point. Yes, paragraph 108, page 113 of the authorities, tab 7, the SC case.
Sorry, the paragraph.
108, page 113.
Sorry.
Shall I just?
Should we just read that?
Yes, I'll just read it. He said there that the court has also adopted a strict approach to differential treatment on the grounds of race or ethnic origin, stating that no difference in treatment based exclusively or to a decisive extent on a person's ethnic origins is capable of being justified in a contemporary democratic society. And having referred to the Bow case, he then said, it was then said by Lord Reid, the Grand Chamber's observation that discrimination on the basis of ethnic origin is a form of racial discrimination indicates that discrimination on the ground of race would be treated in the same way.
I'm not sure if Elias was referred to. I'm just looking at the cases referred to in the judgment. See page 70.
In the judgment of
In SC.
oh, sorry, yes, forgive me.
I was looking to see whether there was a citation of that decision of this court in Elias.
I don't think it was mine.
No. Anyway, you say it's consistent.
Yeah, it's consistent. Yes, and I think there the Lord Reid was addressing the approach of the European Court. I think he did go on to address, yes, domestic courts in paragraph 143 onwards, page 124. The learned judge looked at the decision of the Supreme Court in the case of Humphreys you'll see in doing so, I think it's paragraph 149 onwards. He says at 151, I do not doubt the correctness of that decision, but it now appears to me that the reasoning on justification following the submissions made did not reflect the Strasbourg jurisdiction entirely correctly. First, it seems to me that the manifestly without reasonable foundation formulation as used in the Strasbourg judgments does not express a test in the sense of a requirement whose satisfaction or non-satisfaction will in itself necessarily be determined in the outcome. The phrase indicates the width of the margin of appreciation and hence the intensity of review, which is in principle appropriate in the field of welfare benefits among other things being equal. He then says, as I've explained, however, a number of other factors may also be relevant in the circumstances of particular cases, some of which may call for a stricter standard of review. One might then ask, for example, in a case concerned with suspect grounds, whether very weighty reasons have been shown having regard to the wide margin generally available in that field. And then, however, it's put, the question is more complex than a test of whether the policy choice is manifestly without reasonable foundation might appear to be, if that were regarded as the entirety of the inquiry. And then in paragraph 152, he again talks about differential treatment on suspect grounds. Bottom of, at the end of line 6, he says, differential treatment on suspect ground, on a suspect ground, if it's capable of justification at all, generally, but not always, requires to be justified by very weighty reasons. And then one can read on and see how he puts it. My lords, this is leading us into ground 4, but and due deference. But can I just ask your lordships to note that turning over the page 128 to 129, Lord Reid provides us with his conclusions on the term manifestly without reasonable foundation, or at least the approach. And at paragraph 159, having said that it's important to avoid a mechanical approach to these matters, in the bottom of the paragraph, he says, but as a general rule, differential treatment on grounds such as sex or race nevertheless require cogent justification.
So where are you reading from?
Paragraph 159.
You can just read the whole paragraph.
Perhaps just,
Just read out bits of it.
perhaps just read, if
Would
you
you,
wouldn't mind reading.
we're
the whole-
invited, I think, to read the whole of 159.
Yes, please.
Oh, I see. So it's right. So you jumped over a bit.
I did, my lord, yes.
Sorry to be slow.
Well, we undertake, I can confirm, that
I'm
we
grateful,
will read
thank you.
carefully the whole of the sideline passages.
Thank you.
Sorry. But you don't ask us to do that straight away now.
I don't, my lord, no, thank you. Very weighty reasons, cogent justification, ultimately leaves your lordships.
It's a complete smorgasbord. Manifestly without reasonable foundation.
Exactly, my lord.
How many ways can you formulate what is ultimately pretty much the same test?
Each case will have slightly different
Of course.
circumstances, and your lordship has those circumstances. I was going to move on now to the third ground.
Right, so we're going to ground 3.
Perhaps just the final point I'd make on ground 2, sorry, forgive me, is that my learned friend didn't take the pleading point in the course of the hearing before Mr. Justice Pepperall, and Mr. Justice Pepperall didn't raise the issue with the appellant during the course of the proceedings. And had he done so, certainly we would have made the submissions that were made today.
Will you say, perhaps, in essence, that race is pervasive in this claim and in this appeal, therefore, even if not articulated in the way that it might have been in the pleadings.
Yes.
The reality of the case is that this is a case about gypsies and travellers, in particular about a Romany gypsy, and inherent in the argument put forward, and indeed in the case as a whole, is the factor of race.
My lord, yes. And in addition, this court, as with the court below, has an obligation under the Human Rights Act to act compatibly with the convention. So one cannot ignore, in my respectful submission, the impact on race and the ability to live in accordance with the traditional way of life. In caravans, which the European Court of Human Rights has indicated is worthy of respect, and indeed ought, all other things being equal, to be facilitated.
Right. So ground 3?
Ground 3, my lord. We deal with this ground in paragraphs 44 to 62 of our skeleton argument, beginning at page 82 of the core bundle. Perhaps I can deal with the ground in this way. Before one can conclude whether discrimination under Article 14 is justified, whether the discriminatory measure is a proportionate means of achieving a legitimate aim, or, in other words, the objective, one must first correctly identify the measure itself, and then the legitimate aim of that measure. And if one fails to do so, as we say in this case, the learned judge did, then the assessment is bound to be flawed. It's important not to confuse the aims and the means deployed to achieve it. One sees that reflected in the judgments which are provided in the bundle, and I'm just going to give your lordships a reference without taking your lordships to it, if that's acceptable. The Elias case, which we've just held up, tab 18, paragraph 145. So one needs to look at the contemporaneous evidence and to regard any ex post facto or after the event reasoning with a degree of circumspection and give it all the greater scrutiny. That point is made clear by Lord Carr in the Brewster case, which your lordships will find at tab 12 of the authorities bundle, which begins at page 307.
Do you want us to look at that, or is it the passage that you've cited?
I think it's the passage that's cited, my lord. It's paragraph, if I can just, for your note.
Yeah, this is about the concept of reasons proffered in defence of a decision not present in the mind of the decision maker at the time the decision was made.
Exactly, my lord.
Yeah.
And paragraphs 50 to 52.
Right. So
is where I would invite your lordships to
50 to 52.
Look. It's worth noting, though, my lords, that in this case, the post hoc or after the event reasoning doesn't come, in my respectful submission, from a witness giving evidence, but from my learned friend on instruction. So the measure, in this instance, that one has to first focus on was the adoption of a new and restricted definition of the planning policy for travellers' sites, Gypsy and Traveller definition. And the undoubted aim, for better or for worse, was to make it more difficult for those who were excluded from the new definition to obtain planning permission, by depriving them of the advantage of relying on the relaxed, permissive policies in planning policy for traveller sites. That's reflected in the contemporaneous material and the public sector equality duty analysis, which Mr. Gallagher exhibited. And perhaps just ask your lordships to turn up the supplementary bundle and Mr. Gallagher's witness statement.
Yes. Do you want us to keep open, Brewster?
My lord.
We've noted the passage that.
Yes, I don't think you need to keep open, Brewster, for this purpose. There is one other passage that I'm going to take you to, but it's in relation to ground 4.
All right. Well, we can put away
So
Brewster at least
I'm grateful. Thank you.
until the adjournment.
Yes.
Probably. And
So
yes. Where do we go now?
We're going to the supplementary bundle, my lord, and the public sector equality duty analysis of January 2015, which is to be found at page 151 of the supplementary bundle.
Thank you.
151.
51. This is exhibited to Mr. Gallagher's witness statement.
It is, my lord, yes. I think we'll find that there are possibly two versions. Well, if I can take you to the key paragraphs without having to take your lordships through, as it were, the email trails, which can sometimes be somewhat hard to follow.
What's the date on this?
I think it's January of 2015. It doesn't get more specific than
Right.
that, my lord.
So the status of this document is what exactly?
It's a public sector equality duty analysis of the effects of various proposed changes to PPTS, so the version that we've seen at 2012. And one can see at page...
And the date, sorry, is January
2015.
January 2015.
15,
It was attached to an email, which you'll find at page 143. That email was, there's some redactions, but it was sent on the 29th of January 2015 at 15:03. And it says, please see attached submissions and annexes. And then there's an issue to set out the proposed government response to the Planning and Travellers consultation. This includes a detailed analysis of the proposals and alternative options in light of the public sector equality duty to inform your decision, and then a recommendation that you agree, having considered the summary of consultation responses and public sector equality duty analysis conducted for each of the proposals and alternative options, that we take forward work on the following package of proposals. And the first one is amend the definition to remove the words "or permanently." And then
Well, that's part of it. There's something else which is redacted.
well, that's true, my lord, and I haven't.
It could say, we know this is discriminatory, but bang on anyway.
I'm afraid
Anyway, there
we
it is.
don't know what it says.
This redacted email refers in the first bullet point to the definition of the words "all permanently."
My lord, yes. Can I? Something I haven't.
The deletion of the words "or permanently," I think.
The deletion of
Yes.
What did I say?
Definition.
Oh, sorry, deletion, yes.
Yeah.
As an aside, and it's not, I don't represent any travelling show people here,
No.
but your lordships will have perhaps already appreciated that the definition change applied not just to gypsies and travellers, but also travelling show people. So any elderly or disabled travelling show person who might want to seek planning permission for a permanent site would be faced with the same problem. Anyway, nobody's intervened on the part of travelling show people, but what one doesn't see in any of the assessment or the analysis is any specific analysis of the impacts on travelling show people. It's another flaw, but perhaps not part of my case.
Right.
So, Mr. Wills, just to steer us back, if I may, towards where we were, I think
Yes.
paragraph 12 of the email,
Yes.
which is page 148, explains the PSED assessment, which you were going to take us to, although but
Exactly, my
perhaps
lord.
not
Thank you.
this moment.
No, I'm grateful.
Is
And-
it, how, because we've reached 1 o'clock and beyond, how long will this segment take?
It will take a little while, my lord. I'll just leave you with perhaps with the key point.
All right,
Which
well,
one
fine. I mean, we
if you
can.
don't mind.
I mean, if it was going to be 5 minutes, we could take it. But I think if it's going to take a little while, let's come back. But if you want to leave us with one thought, by all means, share that.
It is one thought, and it's perhaps it's best made once as opposed to repetitively. When one looks at page 151 and the public sector ecology duty analysis, one sees the heading Ensuring Fairness in the Planning System. Proposal 1, amend planning definition. The proposal to amend the definition to remove the words or permanently, to limit the definition to those who have a nomadic way of life. And then 2, the objective to ensure the planning system applies fairly to all. Now there is some text below, which I'll take you to after lunch, which, as it were, expands on that objective. But the objective is set out plain and simply in that and other documentation which reflects this text that was produced and exhibited by Mr. Gallagher.
Right. Well, fine. Well, we can come back to that then after the adjournment. We'll come back at 2:05, expecting you to have completed your submissions by 3 o'clock.
Thank you all.
Thank you very much. Then 2:05.